Ever made a deal with a neighbor, like a simple handshake agreement? Maybe you both agreed, they wouldn't build some huge fence that blocks all your sunlight.
Yeah, seems straightforward enough at the time.
Right. But what happens when they sell up? Does that promise still count? That's the kind of thing that throws us right into today's topic, freehold covenants.
Exactly. These are agreements about how land can be used, and the really interesting bit is they can bind future owners. That's why they matter so much.
And today, we're really going to, well, drill down to help you nail the key rules. Think of this as like a focused session for anyone facing exams on this.
Yeah, we'll flag the crucial bits, repeat them a few times, make sure they stick in your mind. For recall.
Okay, so what are freehold covenants? Let's maybe unpack that a bit.
Fundamentally, they're promises made in a deed that's the formal legal document, usually between neighbors, about what someone will or won't do on their land.
And at first, it's just contract law, right? The original people who signed are bound.
Yeah.
Simple.
Simple enough. But yeah, it gets tricky when the properties change hands. Does the promise travel with the land? Does the benefit the right to enforce it and the burden the obligation to follow it pass on?
And that's where we need to look at both common law and equity.
Precisely. Common law has its traditional rules, often quite strict, and then equity steps in sometimes to provide fairness where the
Yeah.
common law might fall short.
It's not just some, dusty old legal thing, though, is it? Before we had all the modern planning laws telling us what could be built where.
Oh, absolutely. These covenants were vital. They regulated land use, helped maintain property values, prevented chaos, really, kind of like a mini planning system run by neighbors.
Okay, so our mission today. Explain how these covenants work, who gets bound under what rules, and importantly for anyone studying, we'll be repeating the key stuff cases sections to help it sink in. Ready?
Let's do it. First up, passing the benefit. How does the right to enforce that promise get passed on? Let's start with the common law position.
Okay. As we said, the original person who benefits the covenantee can always sue the original person who made the promise the covenantor. That's just basic contract.
Correct. But what about the people who buy the land later? How do they get the benefit at common law? Well, there are a few specific ways.
Okay.
One possibility involves Section 56 of the Law of Property Act 1925. That's Section 56 LPA 1925. Now, this can allow someone who isn't strictly a party to the deed, but is clearly identified in the deed as someone intended to benefit, to enforce it.
So if the deed said, this covenant is for the benefit of my neighbor Jane Smith and her successors in title, maybe Section 56 LPA 1925 could help.
Well, that wording points more towards annexation, which we'll get
Sure.
to. But Section 56 LPA 1925 is more about people named or identified at the time. The key thing to remember, though, is that Section 56 LPA 1925 generally doesn't help future owners who weren't identifiable when the deed was made. So remember that. Section 56 LPA 1925 doesn't usually cover future owners.
Got it. Limited scope there. What else?
Well, for covenants made after 11 May 2000, there's the Contracts, Rights of Third Parties, Act 1999. That date again, 11 May 2000. This act can potentially give rights to future owners if the covenant expressly says it benefits them or clearly intends to.
Okay, so that Contracts Rights of Third Parties Act 1999 could be wider than Section 56 LPA 1925 for those later covenants. If it says benefits the owner for the time being of Whiteacre.
Potentially, yes. It's a different mechanism. But beyond these acts, the two main ways the benefit passes at common law are assignment and annexation.
Right. Express assignment. That sounds like deliberately passing the benefit on.
It is. The original covenantee formally transfers the benefit to the new landowner when they sell the land. And there are rules for this under Section 136 LPA 1925.
Okay, Section 136 LPA in 1925. What does it require?
It requires the assignment to be in writing, and crucially, written notice has to be given to the covenantor, the person with the burden. So for Section 136 LPA 1925, remember, writing and notice.
Writing and notice. Got it. And the other way, annexation. That sounds more automatic.
Exactly. Annexation is where the benefit gets sort of glued to the dominant land. It becomes part of the property itself, so it passes automatically with the land whenever it's sold.
How does that happen? Can it be done deliberately?
Yes, that's express annexation. The wording in the original deed has to make it absolutely clear that the covenant is intended to benefit the land itself, not just the person who owned it at the time.
So just saying, I promise my neighbor Bob, isn't enough.
Generally, no. The classic example of wording that failed is Reynolds v. Cowlishaw. That's Reynolds v. Cowlishaw, 1879, 9 CHD 125. The covenant was made with the covenantee, their heirs and assigns. The court said that wasn't enough to show it was for the land. Remember, Reynolds v. Cowlishaw, 1879, 9 CHD 125 wording needs to benefit the land.
Okay, so you need words like for the benefit of the land known as Blackacre or something similar. What about statutory annexation then? This involves Section 78 LPA 1925, doesn't it?
Yes, here it is. Section 78 LPA 1925. This is a really important one. It can automatically annex the benefit of a covenant to land, provided the covenant touches and concerns the land, meaning it affects how the land is used or its value.
So Section 78 LTA 1925 does the work automatically.
That's the effect, thanks to the case of Federated Homes Ltd v. Mill Lodge Properties Ltd. That's Federated Homes Ltd v. Mill Lodge Properties Ltd. 1981 WLR 594. This case basically said Section 78 LPA 1925 does annex the benefit unless it's excluded. It was a landmark decision. So remember Federated Homes Ltd v. Mill Lodge Properties Ltd. 1981 WLR 594 and Section 78 LPA 1925.
Wow. Okay, so for most covenants made after 1925, Section 78 LPA 1925 is the default, unless they deliberately opt out.
Pretty much. It even applies if only part of the benefiting land is sold off. But there's a slight catch highlighted later in Crest-Nicholson Residential South, Ltd v. McAllister.
Oh, what did Crest-Nicholson Residential South, Ltd v. McAllister 2004 EWCA Civ 410 say?
It said that for Section 78 LPA 1925 to work its magic via Federated Homes, the deed creating the covenant must make the benefited land identifiable. You need to know which land the benefit is attaching to. So remember, Crest-Nicholson Residential South Ltd v. McAllister 2004 EWCA Civ 410 identifiable benefited land is key.
Okay, so Section 78 is powerful thanks to Federated Homes, but Crest-Nicholson puts a boundary on it. Clarity is still needed.
Exactly. And parties can exclude Section 78 LPA 1925. The case Roque v. Chada, 1984 1 WLR 40 is the authority here.
Roque v. Chada, 1984 1 WLR 40. How did they exclude it?
The wording in the transfer basically said the benefit would only pass by express assignment. That was enough to stop Section 78 LPA 1925 applying automatically. So, yeah. Roque v. Chada, 1984 1 WLR 40 shows you can opt out.
Okay, quick recap for the exam memory banks. Benefit at law. Section 56 LPA 1925 for some original beneficiaries. Contracts, Rights of Third Parties Act 1999 for post-11 May 2000 covenants potentially. Then express assignment under Section 136 LPA 1925, writing, notice, and annexation mainly statutory via Section 78 LPA 1925 thanks to Federated Homes, Ltd v. Mill Lodge Properties, Ltd 1981 WLR 594, needing identifiable land per Crest-Nicholson Residential South, Ltd v. McAllister 2004 EWCA Civ 410, unless excluded, like in Roque v. Chada, 1984, 1 WLR 40.
Phew. That's a very solid summary.
Yeah.
Now let's switch tracks to passing the benefit in equity.
Right. Equity, the fairness system. Is it easier here?
It can be more flexible.
Yeah.
The benefit can pass in equity in three ways: assignment, annexation, and through what's called a scheme of development or a building scheme.
Assignment again. Is it the same as at law?
Similar principles, yes. Express assignment is important in equity, especially if Section 78 LPA 1925 has been excluded. The key thing equity adds is that the covenant must protect identifiable land, and the assignment usually needs to happen at the same time the land is transferred. The case Newton Abbott Cooperative Society, Ltd v. Williamson, and Treadgold Ltd 1952 CH286 is a good example.
Newton Abbott Cooperative Society, Ltd v. Williamson, and Treadgold Ltd 1952 CH286. What was key there?
The court was able to work out which land was intended to benefit, even though it wasn't explicitly stated in one part of the documentation. So remember, Newton Abbott Cooperative Society, Ltd v. Williamson, and Treadgold Ltd 1952 CH286 identifiable land is crucial in equity too.
Okay, and annexation in equity.
Similar to law, the benefit attaches to the land.
Mm.
Express annexation needs clear words showing the intention to benefit the land itself, not just the current owner. Remember Reynolds v. Cowlishaw, 1879, 9 CHD 125, just saying heirs and assigns wasn't enough?
Got it. Now this third one, scheme of development or building scheme. This sounds like something for like housing estates.
Exactly. It's like a local law for a specific area, usually set up by a developer who sold off plots of land. The idea is that all the owners can enforce the covenants against each other because they all bought into the same set of rules. So
everyone agrees not to paint their house bright pink or something like that. What are the official requirements?
The classic case is Elliston v. Reacher, 1908, 2C665. Elliston v. Reacher, 1908, 2C665 set out 4 conditions. 1, common seller. 2, plots laid out in advance. 3, mutual restrictions intended for mutual benefit. And 4, the buyers knew they were mutually bound. Let's repeat. Elliston v. Reacher, 1908 2C at 665, common seller, prior layout, mutual restrictions, and knowledge of mutuality.
That sounds quite rigid.
It was interpreted strictly at first. There was also a later case, Reed v. Bickerstaff, 1909 2CH 305, which added that the area of the scheme must be clearly defined. Remember, Reed v. Bickerstaff, 1909 2CH 305, defined area.
But is it still that strict?
The modern approach is more relaxed. Cases like Baxter v. Four Oaks Properties, LTD 1965, CORD 816, Reed Dolphins Conveyance 1970, COID 654, Emil Elias & Co., LTD v. Pine Groves, LTD 1993, 1WLR 305, and more recently Birdlip v. Hunter, 2016, EWCA Civ 603 show this. Lewis and LJ and Birdlip gave a useful summary of common features. The courts now look more at the overall intention for mutual enforceability within a defined area. So remember those cases. Baxter v. Four Oaks Properties, LTD 1965, C618, Reed Dolphins Conveyance 1970, C654, Emil Elias 1993, and Birdlip v. Hunter 2016, EWCA Civ 603, and Lewis and LJ summary.
So less ticking boxes from Elliston v. Reacher 1908 to CS665, more about the clear intention.
Yes, but that clarity, especially about the area covered by the scheme, is still absolutely vital. The case Woodgift Homes v. Stocks, 2001, EWCA Civ 1732.
Yes, Judge LJ in that case stressed that if you can't clearly identify the extent of the scheme land, the scheme fails. Certainty is key. Remember, Woodgift Homes v. Stocks, 2001, EWCA Civ 1732, and Judge LJ on certainty. Okay, let's try summarizing benefit inequity. Express assignment needs identifiable land. Think Newton Abbott Cooperative Society Ltd v. Williamson and Treadgold Ltd 1952 CH 286. Annexation needs clear intent for the land. Recall Reynolds v. Cowlishaw 1879 9 CHD 125. And schemes of development rooted in Ellison v. Reacher 1908 2 CHG 665 plus Reed v. Bickerstaff 1909 02C 305 for area, but more flexible now per cases like Baxter and Birdlip, yet needing certainty per Woodgift Homes.
Excellent. Now let's take a deep breath.
Yeah.
Because we need to talk about passing the burden.
This is where it gets really tough, isn't it? Can the obligation, the actual burden of the promise, stick to the land when it's sold according to common law?
The straightforward answer at common law is no. The burden of a covenant does not run with the land at common law. Full stop.
Really? Just doesn't pass?
Doesn't pass. This was established way back in Osterbury v. Oldham Corporation, 1885, 29 CHD 750, and decisively confirmed by the House of Lords in Roan v. Stevens, 1994, 2 AC 310. So remember those two cases. Osterbury v. Oldham Corporation, 1885, 29 CHD 750, and Roan v. Stevens, 1994, 2 AC 310. No burden passing at law.
So if my neighbor promised the previous owner of my house that they'd, say, contribute to maintaining a shared path, I can't force them to pay based on that original promise at common law.
Correct. The common law view is you can't force obligations onto someone who wasn't party to the original agreement just because they bought the land.
But surely people have found ways around this. It seems like a major gap.
Oh, absolutely.
Yeah.
Lawyers are creative. Various methods exist, like using long leases instead of freeholds, setting up common hold structures, creating complex chains of indemnity covenants where each buyer promises the seller they'll comply.
Indemnity chains? Like passing the buck?
Sort of, yes. Or using the doctrine of mutual benefit and burden.
That sounds promising. Mutual benefit and burden.
Yes, this comes from the case Halsall v. Brazel, 1957, Chief 169. Halsall v. Brazel, 1957, Chief 169. The basic idea is, if you choose to take the benefit of something granted in a deed, you've also got to accept the burden that goes along with it.
Like if I have the right to use a private road, I might have to pay towards its upkeep.
It's exactly that kind of situation. But there are conditions. Lord Templeman and Roe v. Stevens, 1994, 2 AC 310, confirmed the principle, but also highlighted its limits.
What are the limits?
Okay. The benefit and the burden must be linked, usually conferred in the same transaction. They have to be substantively related. And, crucially, the successor must have a genuine choice to take the benefit. If they have to take the benefit, they can't be forced to take the burden. Cases like Thames Meatown Ltd v. Ality, 1998, 30 HLR 1052, Davies v. Jones, 2009, EWCA Civ 1164, and Wilkinson v. Cardine Ltd. 2013, EWCA Civ 44 explored these requirements. Also, Goodman v. Elwood, 2013, EWCA Civ 1103 discussed its nature. Remember Lord Templeman's points in Roan and those cases. Timsme, Davies v. Jones, Wilkinson v. Cardine, and Goodman v. Elwood. So
the ability to choose whether to take the benefit is key.
It's generally seen as essential. If you can't renounce the benefit, you can't be bound by the burden under this doctrine.
You mentioned common hold earlier. What's that about?
The Common Hold and Leasehold Reform Act 2002 introduced common hold as a new way of owning property. sort of like freehold flats, intended partly to solve the problem of enforcing positive covenants. Remember the act. Commonhold and Leasehold Reform Act, 2002.
Has it worked?
Uh, Not really taken off as hoped, partly because of complexities and maybe the continued influence of Roan v. Stevens 1994 to AC 310. The Law Commission has made recommendations for reform, like in Lawcom 394, to make it more attractive. So remember Lawcom 394 for potential reforms.
So common law burden did generally know with some workarounds like indemnity or the Hall-Saul v. Brazel 1957 Sequence 169 doctrine if benefit burden linked and choice exists. And common hold is still developing. What about the poor person who made the promise originally?
The original covenantor. They remain liable on the covenant under contract law even after they've sold the land.
Forever.
Potentially, yes. But the remedies against them might be limited, especially if they no longer own the land and can't actually stop the breach. The covenantee might only get damages.
Right, okay. So the burden outlaw is a minefield. Let's turn to equity again. Does equity help make the burden stick?
Yes, this is where equity really steps in, but mainly for restrictive covenants. This all goes back to the hugely important case of Tolk v. Moxe, 1848, 47 ER 1345.
Tolk v. Moxe, 1848, 47 ER 1345. That's the big one for the burden and equity, right?
Absolutely fundamental. Remember Tolk v. Moxe, 1848, 47 ER 1345. It established that in certain circumstances, the burden of a restrictive covenant can run with the land in equity and bind successors.
Okay, what are the circumstances? What are the requirements from Tolk v. Moxe?
There are essentially 5 key requirements that need to be met for the burden of a restrictive covenant to pass in equity.
5. Okay, number 1.
1. The covenant must be negative or restrictive in nature. It must stop someone doing something rather than require them to actively do something, like spend money. The case here is Haywood v. Brunswick Permanent Benefit Building Society, 1881, 8 QBD 403. Remember, Haywood v. Brunswick, 1881, 8 QBD 403 must be restrictive.
Okay, not to build, restrictive. To maintain a fence.
Right.
Positive. Got it. 2nd.
Second, the covenant must touch and concern the burdened land. It must relate to the use or value of the land itself. Same test as for the benefit.
Right. 3rd.
Third, the covenant must have been imposed to benefit land retained by the original covenantee. There must be a dominant tenement that benefits from the restriction on the servient tenement. You can't just have a restrictive covenant floating free.
So there needs to be benefiting land nearby.
Yes. London County Council v. Allen 1914 3KAB 642 is the classic case showing if the covenantee doesn't own any benefiting land, the burden can't run in equity. And we saw Newton Abbott Cooperative Society Ltd v. Williamson and Treadgold Ltd 1952 CH 286 earlier, confirming the need for identifiable benefiting land. So remember, LCC v. Allen 1914 3KB 642 and Newton Abbott 1952 CH 286 must protect retained dominant land.
Okay. 4th requirement.
Fourth, the original parties must have intended the burden to run with the land. Now, for covenants made after 1925, Section 79 LPA 1925 creates a presumption that they did intend the burden to run, unless a contrary intention appears. So Section 79 LPA 1925 helps here.
A presumption. But it can be rebutted.
Yes. For example, in Morells of Oxford Ltd v. Oxford United Football Club 2001 sheet 459, the court found the covenant was intended to be purely personal, despite Section 79 LPA 1925. So remember Section 79 LPA 1925 presumption, but check for contrary intent, like in Morells of Oxford Ltd v. Oxford United Football Club 2001 sheet 459.
And the 5th and final requirement.
5. The successor must have notice of the covenant. How notice works depends on when the covenant was created and whether the land is registered or unregistered. Before 1926, it was the old doctrine of notice. For unregistered land post-1925, restrictive covenants need to be registered as Class D land charges. For registered land, especially under the LRA 2002, a notice must be entered on the charges register of the burden title. So remember the dates 1926 and the LRA 2002 impact the notice requirements.
Okay, let's recap the burden and equity via Tolk v. Moxe, 1848, 47 ER 1345. 1. Negative restrictive per Haywood v. Brunswick, 1881, 8 QBD 403. 2. Touches and concerns burden land. 3. Protects dominant land retained by covenantee per LCC v. Allen, 1914, 3 KB 642, Newton Abbott, 1952, CH 286. 4. Intention for burden to run, presumed by Section 79 LPA 1925 post-1925, but rebuttable like in Morells 2001 C. 459, And 5, the successor has notice via registration or doctrine of notice depending on Bates system, think 1926, and LRA 2002.
Spot on, and it's worth repeating what Lord Templeman said in Roan v. Stevens, 1994, 2 AC 310. Equity enforces negative promises because it stops someone doing something they shouldn't, but it's reluctant to force someone to actively do something, especially spend money. That covers how burdens might pass. But what if circumstances change dramatically? Can these things ever be, gotten rid of or changed, discharged or modified? Yes, it's possible. Sometimes courts might just refuse to grant an injunction if the claimant has delayed too long or acquiesced in breaches. That's the doctrine of latches or acquiescence. Cases like Chatsworth Estates Covey Fuel 1931 1 Cs 224 and Shaw v. Applegate 1977 1 WLR 97 touch on this. So remember Chatsworth Estates 1931 1 CJ 224 and Shaw v. Applegate 1977 1 WLR 970 for potential refusal based on delay or inaction.
So if you ignore breaches for years, you might lose the right to complain.
Potentially, yes. But the main statutory mechanism is Section 84.1 of the Law of Property Act 1925. That's Section 84.1 LPA 1925. This gives the Lands Tribunal, now the Upper Tribunal, Lands Chamber, a discretionary power to modify or completely discharge restrictive covenants. Note, only restrictive ones. Remember Section 84.1 LPA 1925 and the Lands Tribunal, Upper Tribunal.
And on what grounds can the Lands Tribunal do this under Section 84.1 LPA 1925?
There are several grounds laid out. For example, if the covenant is obsolete because the neighborhood has changed significantly, or if it impedes some reasonable use of the land and money compensation is adequate for any loss and it doesn't provide substantial benefits or isn't contrary to public interest, or if everyone who benefits agrees, or if the change won't injure the people entitled to the benefit. Those are the main grounds in Section 84.1 LPA 1925. Obsolescence, impeding reasonable use, agreement, no injury.
Do they use this power freely? Like if I get planning permission to build something the covenant forbids?
They tend to be quite cautious. It's a discretionary power. The Supreme Court case Alexander Divine Children's Cancer Trust v. Housing Solutions Ltd. 2020, UKSC 45, reinforced that the tribunal takes a careful approach, especially if someone deliberately flouts a covenant. And getting planning permission doesn't automatically mean the covenant will be discharged. So, remember Alexander Divine Children's Cancer Trust v. Housing Solutions Ltd. 2020, UKSC 45. Cautious approach. Planning permission isn't decisive.
So modifying or discharging isn't a walk in the park. Are there bigger reforms being discussed?
Yes, definitely. The Law Commission looked at this whole area in detail and published a report back in 2011 called Lawcom 327. They proposed creating a completely new type of interest called a land obligation. The idea was it could cover both positive and negative obligations and would run with the land more easily. Remember the 2011 report, Lawcom 327, and the idea of a land obligation.
A land obligation sounds simpler. Is that happening?
The government has indicated some intention to implement parts of it, but, well, these things often take time. It highlights that this area is still seen as complex and perhaps ripe for modernization.
Okay, so wrapping up, it's a complex picture. Different rules for benefit and burden, different rules at law and in equity.
That's the key takeaway. Benefit passing, think Section 78, LPA 1925, and Federated Homes 1981, WLR 594 at law, and annexation or schemes like Elliston v. Reacher 1908, 2C 665 in equity. Burden passing, generally no at law, Osterberry 1885, 29 CST 750, Roan v. Stevens 1994, 2 AC 310. But yes, for restrictive covenants and equity, if the Tolk v. Moxe 1848, 47 ER 45 conditions are met.
And discharge or modification mainly hinges on Section 84.1 LPA 1925 for restrictive covenants, used cautiously by the Lands Tribunal, Alexander Divine 2020, UKSC 45.
Precisely. It's a fascinating balance, isn't it, between one person's right to do what they want with their land and the elective interest in maintaining certain standards or characteristics in an area through these agreements.
It really is, and it makes you think, what are the pros and cons of making these things easier to enforce? Like with that proposed land obligation, how does that balance shift? Something for you to ponder.